obligations comprise the ways in which an obligation can be terminated or extinguished. The first one is by payment of performance. In this case, the debtor can decide to pay back his debt to the creditor by which of a service or a performance as compensation for the debt. Now the second one is by the loss of a thing due. In this scenario, the debtor is entrusted by the creditor with a certain object or thing. Now this item is lost, the obligation is extinguished by the fact that the object itself is the prerequisite to how the obligation can be fulfilled. Now, the third one is the condonation or remission of the debt, in which case its literal meaning, forgiving an offense. This is where the creditor forgives the debtor rather than enforcing him to do his or her obligation. Now, by the fourth one, we have by confusion or merger of the rights of the creditor and debtor. Now, in this scenario, the creditor and the debtor share the same identity or they are the same person, in which case the obligation is directly extinguished, since you are unable to actually owe or claim anything from yourself. Now, the fifth one is by compensation. This happens when the two parties are reciprocally the creditor and the debtor to each other. Now, they exchange their obligations as the instrument to extinguishment of this obligation to each other. Now, the sixth is by novation. In this case, the old obligation is replaced with a new obligation in its place. The 6 ways previously enumerated are the most common ways where an obligation can be extinguished. Aside from these, we have other causes governed by this code. We have annulment, rescission, fulfillment of a resolutory condition, prescription, the death of a party in case an obligation regarding personal service. And lastly, but certainly not least, we have manual desistance or withdrawal.
Section 1. Payment or performance discusses on the first way, how an obligation can be extinguished. Article 1232 defines payment according to the law. So, what is payment? Payment has 2 meanings. The first one is used in common conversations, which refers to only the delivery of money. The second one is according to the law or the legal mode, which goes beyond the first definition. Payment may also pertain to the act of giving, doing, or not doing an act. It may also refer to the damages or penalties of doing the contrary of giving, doing, or not doing.
Article 1233 states that a debt shall not be understood to have been paid unless a thing or service in which the obligation consists has been completely delivered or rendered, as the case may be. A debt may refer to an obligation to deliver money, to deliver a thing other than money, to do an act, or not to do an act. Article 1233 provides 2 characteristics of prestation, which are the integrity of prestation and the identity of the prestation. Integrity of prestation means that the debt to deliver or render service are not understood to have been fully paid if the thing or service has not been completely delivered or rendered. This means that the partial or irregular performance will not extinguish the obligation. For example, Mr. S obliged himself to deliver 100 sacks of beans to Mr. B. However, Mr. S only delivered 90 sacks of beans. So this means his obligation is not fulfilled. On the other hand, identity of the prestation means that the very prestation required by the debtor to perform must be delivered or rendered. This basically means that it is up to the debtor to extinguish his debt by delivering or performing his or her obligation.
Article 1234 states that if an obligation has been substantially performed in good faith, the obligor may be as though recovered there had been a strict and complete fulfillment, less damages suffered by the obligee. Substantial performance is a fulfillment of the obligation agreed on the contract with only slight variances or omissions of unimportant details or minor defects. Article 1234 then means that if an obligor complies the obligation where good faith is observed, there is a tendency that he or she may not compensate for the full damages injured by the obligee, and if the obligor follows a strict and complete fulfillment issued by the court. For example, Lance obliged himself to deliver 500 bags of cement to Tasha for the amount of 1,000. Despite all his diligent efforts, Lance was only able to deliver 400 bags due to the shortage of supplies. Nevertheless, Lance wants to comply his obligations and deliver entirely the 500 bags, but he could not do so due to the reasons that he cannot control. Article 1234 supports this situation wherein Lance may recover as though there had been a complete delivery less the price of 100 bags. Lance must show, however, that he attempted in good faith to comply his obligations.
Article 1235. When the obligee accepts the performance, knowing its incompleteness or irregularity, and without expressing any protest or objection, the obligation is deemed fully complied with. Recovery is only allowed when incomplete or irregular performance is waived. This provision is the other exception to Article 1233. It is founded on the principle of estoppel. First, if the payment is incomplete or irregular, the creditor may properly reject it. Second, in case of acceptance, the law considers that he waives his right. The whole obligation is extinguished. So what are the requisites for the application of Article 1235? The requisites are: the obligee knows the performance is incomplete or irregular, and he accepts the performance without expressing any protest or objection. The article states that if the obligor performs a task incompletely or irregularly, and it is accepted by the obligee without complaining or objecting, knowing that it is incomplete or irregular, then the obligation is considered completely fulfilled. This provision is founded on the principle of estoppel, which prevents someone from using an argument that contradicts what they previously said or agreed to by law. In the case of incomplete fulfillment of the obligation, it can be considered completely fulfilled if the obligee accepts the performance knowing that it is incomplete and if he does not express objection. The law will consider that he permits the incomplete performance with approval if one or both requirements of the provision is or not met. Article 1235 cannot be applied. The obligee has the right to properly reject the incomplete performance offered by the obligor. On the other hand, if he accepts with full knowledge of the incompleteness of the task and if he does not express objection.
Article 1236. The creditor is not bound to accept payment or performance by a third person who has no interest in the fulfillment of the obligation unless there is a stipulation to the contrary. Whoever pays for another may demand from the debtor what he has paid, except that if he paid without the knowledge or against the will of the debtor, he can recover only in so far as the payment has been beneficial to the debtor. The creditor is bound to accept payment or performance from the following: the debtor, any person who has an interest in the obligation like a guarantor, and a third person who has no interest in the obligation when there is stipulation that he can make payment. However, creditors can refuse to accept payment from third persons. The old civil code prohibits this, but the Commission believes that the creditor should have a right to insist on the liability of the debtor.
What would happen if payments or performances are made by a third person? If made without the knowledge or against the will of the debtor, the payer can recover only up to the extent or amount of the debt at the time of payment. Furthermore, the third person is not subrogated to the rights of the creditor, such as those arising from a mortgage, guarantee, or penalty. An example of recovering only up to the extent or amount of debt at the time is when S, a stranger or third party, paid C, the creditor, an amount of 1,000. However, an amount of 400 has already been paid by the debtor. Therefore, the stranger is entitled to be reimbursed by the debtor only for the amount of 600, and S can recover the remaining 400 from the creditor, who should not have accepted it in the first place. Also, if the creditor acted in bad faith, he is held liable for interest in lieu of damages. If made with the knowledge of the debtor, the payer shall have the rights of reimbursement and subrogation, and that is to recover what he has paid, which is not necessarily the amount of debt, and to acquire all the rights of the creditor. Example: if the payment of 1,000 was made with the knowledge or consent of the debtor, as the stranger can recover from the debtor 1,000 with all the rights of subrogation to the accessory obligations such as mortgage, guarantee, or penalty.
Article 1237. Whoever pays on behalf of the debtor without the knowledge or against the will of the latter cannot compel the creditor to subrogate him in his rights, such as those arising from a mortgage, guarantee, or penalty. Right of third person to subrogation. It is important to distinguish whether the third party paid with or without the consent of the debtor, as it is only in the absence of consent that Article 1237 applies. When payment is without the knowledge or against the will of the debtor, the third person cannot compel the creditor to subrogate him in the latter's accessory rights of mortgage, guarantee, or penalty. Article 1237 in relation to Article 1236. A third party who pays in behalf of the debtor without the knowledge or consent of the latter does not have the right to subrogation, but only the right to reimbursement. Otherwise stated, the third party cannot force the creditor to transfer his accessory rights, such as enforcement of mortgage, guarantee, and other forms of penalty. The third party is rather only entitled to reimbursement to the extent of the debtor's benefit pursuant to Article 1236. Subrogation and reimbursement distinguish. In subrogation, the person who pays for the debtor is put into the shoes of the creditor. The payer acquires not only the rights to be reimbursed for he has paid, but also all other rights which the creditor could have exercised pertaining to the credit, either against the debtor or against third persons, be they guarantors or possessors of mortgages. In reimbursement, the third person entitled by reason of payment has merely the bare rights to be refunded to the extent provided in the second paragraph of Article 1236, without the right to the guarantees and securities of the original obligation. In subrogation, however, there is no real extinction of the obligation, but only a change of creditor. In this example, if Celso refuses, can Alfredo compel him? No. Under the law, specifically Articles 1236 and 1237 of Republic Act, it is stated that without the knowledge of the debtor, the payer, or the third person, can recover only insofar as the payment has been beneficial to the debtor. If Berto cannot pay Alfredo, the latter cannot proceed against Mang Ben, the guarantor, because, having paid without the consent of Berto, Alfredo is not entitled to subrogation. Hence, the third party cannot force the creditor to transfer his accessory rights, such as the enforcement of mortgage, guarantee, and other forms of penalty. The third person is, rather, only entitled to reimbursement to the extent of the debtor's benefit. However, if the payment was with the express or tacit approval of Berto, Alfredo could be entitled not merely to full reimbursement but also to subrogation. Conclusions. Consequences of payment made by a third person without the knowledge or against the will of the debtor. 1. He can only recover the payment that is beneficial to the debtor. 2. He cannot place himself to have all the rights pertaining to the creditor.
So next is Article 1238. This article states that payment made by a third person who does not intend to be reimbursed by the debtor is deemed to be donation, which requires the debtor's consent. But the payment is in any case valid as to the creditor who has accepted it. So first, who can pay for an extinguishment of an obligation? So generally, it comprises of the debtor, the authorized agent. On behalf of the debtor, it can be his assistant, and the successor in interest. Payment made is considered as valid payment and should be accepted by the creditor, or else, if the creditor will reject the payment, there will be a delay on the part of the creditor called as mora accipiende. However, a third person can pay on behalf of the debtor, given these certain circumstances. First, if the third person is interested in the fulfillment of the obligation. Second, if the third person is not interested in the fulfillment of the obligation. And lastly, if the third person does not intend to be reimbursed. With those certain circumstances, we will just pay attention to the third one, since it is what covers Article 1238, if the third person does not intend to be reimbursed. The creditor may validly refuse the payment, because Article 1238 embodies the idea that no one should be compelled to accept the generosity of another. But if the creditor accepts the payment, the debtor's say shall follow. If the debtor consents the payment, it is deemed to be a donation, which means that the third person may or may not receive any payment by the debtor. So let us consider this example. Tyrus owes Thyra 250,000 pesos. So Tyrus is a debtor and Thyra is a creditor. Without the intention of being reimbursed, Tyson paid Tyrus' obligation. So in this case, Tyson is a third person. Thyra accepted Tyson's generosity. But if the debtor does not consent the payment, here are the consequences. So first, the debtor shall reimburse the third person for what has been beneficial to him or her. And the third person is not subrogated of the rights of the creditor. So let's go back to our example. Tyrus owes Thyra 250,000 pesos. Without the intention of being reimbursed, Tyson paid Tyrus' obligation. And then Thyra previously accepted Tyson's generosity. But at this point, Tyrus did not consent the donation. With that being said, Tyson may still recover from Tyrus since there was no donation. However, he may only recover up to the extent beneficial to Tyrus, which is 250,000 pesos. That's it. That's for Article 1238.
Article 1239 states that in obligations to give, payment made by one who does not have the free disposal of the thing, due incapacity to alienate it, shall not be valid without prejudice to the provisions of Article 1427 under the title on Natural Obligations. Free disposal of the thing due means that the thing to be delivered must not be subject to any claim or charge upon personal property or claim against property of a third person. Examples of these are mortgage and pledge. Capacity to alienate means that the person is not incapacitated to enter into contracts, and for that matter, the tendency to act of the thing due is made. The exception is provided in Article 1427. The creditor cannot be compelled to accept payment where the person paying it has no capacity to make it. For example, S agreed to sell to B a television set. If the television set delivered to B by S belongs to C, the same can be recovered by C because the payment is not valid. S does not have free disposal of the television set. The same right of recovery exists although the television set belongs to S. If he is a minor, he therefore has no capacity to alienate it.
Article 1240 of the Civil Code of the Philippines states that payment shall be made to the person in whose favor the obligation has been constituted, or his successor in interest, or any person authorized to receive it. People who may receive the payment can either be the creditor or obligee, an heir or assignee, or any person who bears the authority to receive it by virtue of an agreement or by law. The creditor referred to must be the creditor at the time the payment is to be made, not at the constitution of the obligation. Thus, if an individual is subrogated to the right of the creditor, payment should be made to the new creditor. Subrogation means to substitute or the assumption of a third party to legally claim the payment. The payment is not valid if the person who received the payment was not authorized by law or by agreement. Paying the wrong party in good faith is not an excuse. For instance, Daniel borrowed 5,000 pesos from Charlie. In this situation, Daniel has to pay Charlie or any individual that was authorized by Charlie to receive the payment, or in case of his death, Daniel must pay to Charlie's heirs or any person authorized by law. It is not an excuse that Daniel acted in good faith in paying the wrong person.
Flashing on the screen is Article 1241, which talks about the effects of a payment made to an incapacitated person or to a third party. The first paragraph of the article, which reads, "Payment to a person who is incapacitated to administer his property shall be valid if he has kept the thing delivered or insofar as the payment has benefited him." The article stresses the fact that payments to incapacitated persons are not valid. However, payments under circumstances where the creditor has kept the thing delivered or has benefited from it to the extent of the amount enjoyed by the creditor are considered valid. This also means that the debtor can be made to pay again by the creditor's guardian or by the incapacitated person himself when he regains capacity. For example, Paul owes John 500,000 pesos. However, in time of Paul's payment, John was already insane. If John kept the payment, Paul's obligation was already extinguished. John was incapacitated to administer his own property, but he kept the thing delivered or the payment, which makes Paul's payment valid. If John exchanged the 500,000 pesos to a necklace worth 200,000 pesos to a swindler, Paul's payment to John remains valid only up to the extent of 200,000 pesos, which is the amount that John really benefited from Paul's payment. It is Paul's burden to prove that the payment has benefited John. In the absence of the benefit, Paul may be made to pay again by John's guardian or by John himself against his capacity. The second part of the video, which provides for the effects of payment to a third person, will be discussed by the ever-charming Miss Marian Pearl Tuliao.
Thank you for that enlightening discussion, the ever-astute and sharp-witted Mr. Tanyakaw. Now, let's proceed with the effect of payment to a third person. Payment to a third person or wrong party is not valid except insofar as it has redounded to the benefit of the creditor. That the creditor was benefited by the payment made by the debtor to a third person is not presumed and must therefore be satisfactorily established by the person interested in proving this fact. In the absence of such proof, the payment thereof in error and in good faith will not deprive of the creditor of his right to demand payment. If a third person receives the payment is valid, but only to the extent of benefit of the creditor. The payment must be proved except in the three following instances. The debtor is relieved from approving benefit to the creditor in case of, first, subrogation of the payer in the creditor's rights. The third party assumes that he would collect the payment. Second, the ratification by the creditor, when the creditor approves that the payment would be made to the third party. Third, estoppel on the part of the creditor. Estoppel could arise in a situation where a creditor informs the debtor that the debt is forgiven, but then later insists upon repayment. Through estoppel, an admission or representation is rendered conclusive upon the person, meaning it cannot be denied or disproved as against the person relying thereon. In conclusion, payment to a third person who is incapacitated to administer his property shall be valid if he has kept the thing delivered, or insofar as the payment kept has been beneficial to him. Payment made to a third person shall also be valid insofar as it has redounded to the benefit of the creditor.
On Article 1242 of the Civil Code of the Philippines, it is stated that payment made in good faith to any person in possession of the credit shall release the debtor. It must be observed that the term possession from the provision refers to the actual possession of the credit itself and not just the instruments that provides evidence for the credit. With this, the possession of the credit instrument does not qualify the holder of it for payment if the payee is not the actual owner of the credit itself. It also does not release the debtor. Another thing is that the payer must act in good faith upon payment. This can be done if the payer has the honest belief that he or she is making the valid payment and the payee is the correct owner of the credit. An example where this provision applies is, let's say Ben is in debt of 3,000 pesos to be paid to Gwen, and also Ben's indebtedness was evidenced by a promissory note signed by Ben in favor of Gwen. However, after a few days, Ben lost his promissory note and another person named Max found it. Afterwards, Max demanded a payment from Ben. In this case, the payment to Max is invalid even though Max is now the holder of the instrument evidencing the credit. This is because what Max possesses is just a credit instrument and not the actual credit itself. However, if paying the current holder of the promissory note is allowed and Ben actually pays Max in good faith, then the obligation will be extinguished. Similarly, if the promissory note was endorsed by Gwen to Max under a private agreement that Max would not collect from Ben, but still Max collected the payment from Ben in good faith, the debt will be extinguished and the right of Gwen will be against Max.
Good afternoon, everyone. My name is Richie Cyrus Hereño of Group 12. I will be reporting on Article 1243 in the Civil Code of the Philippines. The definition of this article is payment made to the creditor by the debtor after the latter has been judicially ordered not to retain the debt shall not be valid. 1165. On an additional note, this article is only applicable in debts or credits, not in property. After reading this, we might have a question in our heads, which is, when is the payment to a creditor not valid? The first point says that the court may order to retain the debt until the right of the plaintiff, the creditor in the main litigation, is resolved. The second point says that the payment made by the debtor stranger after the case shall not be valid if the plaintiff wins the case and cannot collect from the debtor. Such a thing is considered a payment made in bad faith. Next, we have the possible prompts for the judicial order, which are an order of attachment, also known as a writ of attachment, an injunction, which I will talk about in a later slide, and a garnishment. A garnishment is the proceeding by which a debtor's creditor is subjected to the payment of his debt to another. Here is an example of a garnishment. Janine owes Richard 1 million pesos. Richard, in turn, owes Leo 100,000 pesos. Leo brings an action against Richard, who claims insolvency, but admits the credit which he has over Janine. Before Janine pays Richard, Janine is summoned into the proceeding and asked to retain the debt in the meantime. Should Janine again pay Richard in view of the fact that the first payment is not valid under the law? The answer? Janine does not need to pay Richard a second time. At the beginning, the payment was not valid, but the defect here has been cured by the dismissal of the garnishment proceedings. It is as if there had never had been any judicial order asking Janine to retain the debt. Moreover, why should Richard, the creditor, be paid for the same debt? To be paid twice for the same debt. To hold that he should is to allow a travesty of justice, an undue enrichment of Richard. Pending garnishment, may the debtor be judicially ordered to pay the creditor of another? The answer, no. Because under the rules of court, the credit must be given to the clerk, sheriff, or other proper officer of the court, as stated in Section 8, Rule 57 of the Revised Rules of Court. Next, we have something called an interpleader. An interpleader is a technical name of the action in which a certain person in possession of certain property wants claimants to litigate among themselves for the same. Here's an example. Mario has in his possessions some merchandise to be delivered to the person who presents the proper receipt. Ernie and Feli each have a receipt. They ask Mario to turn over the property to one of them. An examination of the receipts reveals that they are of the same kind. Mario does not know to whom he should deliver the property, so he files an action in court by means of which Ernie and Feli will be able to settle their conflicting rights. The court then issued an order prohibiting payment to either Ernie or Feli in the meantime. Despite the receipt of the order, Mario paid Ernie, who is the brother of the latter's sweetheart. Is the said payment valid? The answer? No. The payment here was made after the debtor had been judicially ordered to retain the debt. Evidently, Mario cannot say he paid Ernie in good faith. He had ulterior motives for his act. Otherwise, he would not have disobeyed the lawful order of the court. Under the law, therefore, Mario is deemed to be a payer in bad faith. Now for the last slide. An injunction is a judicial process by virtue of which a person is generally ordered to refrain from doing something or not to do certain things. Here is, again, an example. Ferlin owes Leah a sum of money. When Ferlin is about to pay Leah, the relatives of the latter move to stop the payment on the ground that Leah appears to be insane. However, proceedings in court to determine Leah's sanity are still in progress. Seeing Ferlin's determination to pay, the relatives of Leah ask the court for a writ of preliminary injunction, restraining Ferlin from paying Leah in the meantime. Would it be advisable to pay Leah despite said injunction? The answer, no. It would not be advisable for Ferlin to pay while she is under injunction. Otherwise, her payment would not be valid, since this would then be a payment made to the creditor by the debt, after the latter has been judicially ordered to retain the debt. Thank you for listening to my report.
Article 1244 states that the debtor of a thing cannot compel the creditor to receive a different one, although the latter may be of the same value as or more valuable than that which is due. An obligation to do or not to do, an act or forbearance, cannot be substituted by another act or forbearance against the obligee's will. Very prestation due must be complied with. The first paragraph refers to a real obligation to deliver a specific thing. A thing different from due cannot be offered or demanded against the will of the creditor or debtor, as the case may be. The second paragraph refers to personal, positive, and negative obligations. The act to be performed or the act prohibited cannot be substituted against the obligee's will. When prestation may be substituted, of course, substitution can be made if the obligee consents. In facultative obligation, the debtor is given the right to render another prestation in substitution. In Article 1244 will not also apply in case of waiver by the creditor, or substitution is allowed by stipulation with the consent of the creditor. For example, Dave obliged himself to deliver to Yana a specific carpet. Dave cannot require Yana to accept another carpet, although it may have a higher value. Neither can Yana require Dave to deliver another carpet belonging to Dave, although it can be sold only at a much lower price. The key highlights of Article 1244. First, the debtor cannot compel the creditor to receive a different one. Second, upon agreement or consent of creditor, debtor may deliver a different or perform a different prestation. Third, there may be dation in payment or novation. Waiver of defects. Defects of the thing delivered may be waived by the creditor if he expressly so desires, or with knowledge thereof he accepts the thing without protest, or disposes of it or consumes it. Defining the key terms. Forbearance. It is the action of refraining from exercising a legal right, especially enforcing the payment of debt. Dation. It is the delivery and transmission of ownership of a thing by the debtor to the creditor as an accepted equivalent of the performance of obligation. Novation. It is the extinguishment of an obligation by the substitution or change of obligation by a subsequent one.
Article 1245. Dation in payment, whereby the property is alienated to the creditor in satisfaction of a debt in money, shall be governed by the law of sales. So what is dation in payment? Dation in payment, or dación in pago, is a special form of payment under the Civil Code. It is done by satisfying the outstanding debt in a way of alienation, or, in other words, transference of ownership of a debtor's thing to the creditor as an accepted equivalent to the amount of money debt. Dation in payment is allowed when the creditor gives consent to the fulfillment of the debt. However, if the property being alienated is less than the obligation, the value of the accepted equivalent of the said property will only extinguish the obligation up to the extent of the property's value unless stated and agreed upon both parties. It is governed by the law of sales, as there is an agreement between both parties wherein the debtor transfers ownership of their thing equivalent to the amount of money debt, which is basically the payment to the creditor. The nature of this process is essentially a sale. To have a clearer understanding of this article, here is one example. Ying is indebted to Yang in the amount of 5,000 pesos. Both parties have an agreement that Ying may fulfill his obligation by delivering a TV and will be considered as full payment of the money debt owed to Yang regardless of the thing's value. Upon the delivery of the TV by Ying to Yang, the obligation will be extinguished as per agreement. Since both parties have reached a consensus, the delivery of the TV will result to the full satisfaction of Ying's obligation to Yang.
Article 1246. When the obligation consists in the delivery of an indeterminate or generic thing whose quality and circumstances have not been stated, the creditor cannot demand for a thing of superior quality. Neither can the debtor deliver a thing of inferior quality. The purpose of the obligation and other circumstances shall be taken into consideration. The purpose of this article is to supply justice in cases where there is a lack of precise declaration in the obligation of the quality or kind of thing to be delivered. If there is disagreement between the parties, the law steps in and determines whether the contract has been complied with or not according to the circumstances. The benefit of this article may be waived by the creditor by accepting a thing of inferior quality and by the debtor by delivering a thing of superior quality. Examples with applications to various situations. Watt promised to deliver to Sons a gamecock. Sons cannot compel Watt to deliver a prize-winning gamecock. Neither can Watt require Sons to accept an old sickly gamecock. 1. If Sons own a flock of gamecocks and cockfighting is his main diversion in life, which fact is known to Watt, and the price agreed upon is the reasonable price of a gamecock, then Watt,
must deliver a gamecock. 2. If sons happen to be a chicken farmer and sons agreed to pay what for the chicken, an amount which is reasonable price of a chicken for a farm, then that kind of chicken may be delivered. Third example, if sons is a veterinary doctor and his only purpose in buying a gamecock is to examine its organs in connection with his work, this and other relevant circumstances may show that the old sickly gamecock was intended by the parties to be delivered.
In relation, Article 1247 states that unless it is otherwise stipulated, the extrajudicial expenses required by the payment shall be for the account of the debtor. With regard to judicial costs, the rules of court shall govern. The general rule for this is that the debtor has to pay for the extrajudicial expenses incurred during the payment. Thus, it is the debtor who benefits primarily since his obligation is thus extinguished. However, the exception for this is that when there is a stipulation to the contrary, the debtor pays for the extrajudicial expenses. The extrajudicial expenses of payment are for the account of the debtor. The reason is that the obligation is extinguished when the payment is made, and it is therefore the debtor who is primarily benefited. If the parties have made the stipulation as to who will bear the expenses, then their stipulation shall be followed. Article 1247 does not apply to expenses incurred by creditor in going to the debtor's domicile to collect. Losing party generally pays judicial costs. Under the Rules of Court, Section 1, Rule 142, the cost of an action, as a rule, shall be paid by the losing party. The court may, however, for special reasons, adjudge that either party shall pay the cost or that the same be divided as may be equitable. For example, Mr. Fernandez is the owner of an apartment entered into a lease agreement with Mr. Mendoza for the amount of 10,000 pesos to be paid every 5th of the month. Upon payment of the amount every 5th of the month, it is the debtor who benefits primarily since his obligation is extinguished. But let's just say, for example, Mr. Mendoza failed to make the payment for 4 months despite the oral demands. Mr. Fernandez wishes to have Mr. Mendoza vacate the property and collect unpaid rental fee. He then seeks the advice of Attorney Gonzaga and paid a fee of 5,000 pesos. 2 demand letters were sent via registered mail and incurred 350 pesos for such. Later on, Mr. Mendoza forwarded his intent to vacate the apartment and make the payment for his debt, which shall include the unpaid rental and the expenses incurred upon hiring legal services.